Well, I've handled a number of cases, and I can bring creativity to each case. Now, one example is Radco versus Diamond Walnut. This is one of my first cases after I left the big firms and opened up my own shop. Radco manufactured urethane foam, and they sold it for construction sites to a subcontractor named Midstate. Midstate applied it to Diamond Walnut's roofs. Then they didn't pay Radco. So my client calls me, and how do I get a mechanic lien? I said, well, did you do your 20-day notice? So you have to do a notice to the owner that you're providing materials if you want to get a lien against that owner's property. They didn't do a 20-day notice. The time it expired. You have to do it within 20 days of the delivery of the product to the site. So I said, well, can you go and drive there and pick up these 55-gallon drums, drive them around the block, and then drop them off again? You're releasing possession, and boom, here's your 20-day notice. Well, no, they're all locked up. They're all locked up in a warehouse. So that's just great. So I thought about my conversation with him, and he said Midstate could not pay their bills when due. They were basically insolvent when they purchased that product on credit. I remembered something about my reading of the UCC, Uniform Commercial Code, and if someone buys a good on credit and is insolvent at the time, then you can demand return of those goods and you get constructive possession of the goods. So I demanded the return, and then I now had constructive possession, and then I served a 20-day notice, and I released constructive possession, although the 55-gallon drums never left the warehouse. So I explained this to Diamond Walnut. They laughed at me. I said, do not pay Midstate. And they did. We sued. We won. It was precedent setting because nobody had ever grafted the UCC under a mechanic lien statute. And the judge ordered Diamond Walnut to pay us in full, although they had already paid Midstate, who later filed bankruptcy.